I love this institution. The first time I came into these chambers was somewhere in 1990. I was an intern for the late Charlie Harrison Jr. And when I came into this institution, it was packed with people who'd served decades, many of them who I looked up to as heroes and mentors. And so when I got elected, I took that awe that we all felt that first day when you walked in as an elected official. And to me, as I told members of my caucus earlier today, today is probably the most important vote that I will take in my entire tenure in the State House of Representatives. Because the state constitution gives us the most extreme power, which is to nullify a vote of about 90,000 people. And that is what we have been given the opportunity to do. As you've already heard, it's only happened 3 times in the history of our state, and the last 2 have happened since our 1963 Constitution. From maybe the 4th or 5th day after the Detroit News article, began to hear members, including a member of the leadership team of the majority caucus, start talking about expulsion. It was even before the report was issued, before we actually had witnesses, but we had a member of the leadership team actually talk about expulsion, at least for one of the members. I don't think he said for both, but one of the members. And so from that point forward, I've been grappling with the fact that I knew we were going to end up here today. I'll tell you, I'm a little surprised how quickly we ended up here, but I knew that we would end up here at some point in time. And I really, if you talk to my wife, know how much I have thought about this, calling former legislators, including my mentor who served in this body for 22 years, who actually had served during the Monty Gerald's expulsion from this chamber, and asked them, what did they look at? What did they see? And again, as we've talked about, whether it's the 2 expulsions that have happened since 1963 or the different select committees that were created but resulted in people actually resigning before the expulsion vote, what you saw in every single instance was that there were already criminal charges. And in most cases, the criminal charges had actually worked their way through the court process. Monty Gerald's case, the one that we dealt with here in the House, had actually gone through conviction, and that is why it rose to the conversation and was a felony, mind you, and it rose to that occasion. Across the building, when we expelled David J., and many of us were staffers or we were working with organizations, that individual had 3 drunk drivings, had pending charges of domestic violence, and a whole series of other things added to them. And what I really struggled with is that today we're going to have a vote on expulsion, and we haven't even started a criminal investigation. The past precedence of this chamber has been to allow the legal process to move itself through. And that's one of the reasons why yesterday I put forward my resolution to demand that the state police and the Attorney General take a look at what criminal charges are actually in front of us today. You didn't even, as you made your resolution, ask to send this to the Secretary of State, the Attorney General, or the state police. You could have done it as the report was done. You could have done it as the committee was formed. You could have done it as the committee finished its work. But if you really believe these people should be expelled, why didn't we go through that criminal part of the investigation? So I get to the process. And in the end, process does matter. That is the one thing we can control. I can't control the actions of the 2 members. I find them despicable, the actions that they took. I find it an embarrassment to the institution. But the question is, doing a rushed process is also disrespect to this institution. It should be given the opportunity for us to learn all of the information. So let me start off with my concerns of what that process was. I've already said this to the legal counsel of the majority. I didn't feel it was appropriate for staff to make any recommendations to the members. The Constitution allows us the right to expel members, not staff. We should have had a a member, whether it was the chair of the committee or the Speaker of the House. I feel that that should have been the starting point of a conversation about whether we should expel or do censure. I don't believe it's the role of staff to do that, because again, that piece is really up to member. It is our constitutional duty. I also was concerned with the flow of information. I found out recently that one of the individuals that we're talking about expelling, that she submitted a letter on Friday that my members didn't even get the opportunity to see till Tuesday. There was conversations happening over the weekend, obviously between her legal counsel and the Speaker's office, and my members still did not have access to that information. Tuesday night, we also found out an email that had been exchanged between the legal counsel of one of the representatives and the legal counsel of the majority. We never had the opportunity to see that until the full report was actually presented to the media. My members, and your members, if you weren't on the committee, had the opportunity to receive this on Tuesday afternoon. Not because the House Business Office sent it to us. They didn't. We had to go to a media outlet to get that. If you are asking me to make the most important decision a legislature can make, the most extreme action a legislature could make, you didn't even have the due respect to send me the 800-page report. I had to go to a media site to get access to it. If people were sent to it, I wasn't. I never received that. And then to expect all of us to read through the 800 pages in the 5 hours of video. I can't imagine, unless you've been on the committee, that you've had enough time since Tuesday to actually read every single page and listen to all 5 hours of the audio. And I have not had that opportunity. And that's why it makes it very difficult for me to actually move this process forward at this point in time. Now, I heard my good friend from the UP talk about there being some kind of deal. And now I've read in the media that there was some potential deal between one of the members and the Speaker's office taking a look at potential censure, and I want to know what was offered for that. Oftentimes in court proceedings, when you stipulate to a recommendation, you probably say, hey, stipulate to these facts, and we will then move this forward. So is that what occurred? I don't know that, because nobody during the testimony of individuals talked about that conversation and that deal. I didn't know if that deal was true until I obviously heard that, the chair of the committee has at least heard about this. I just thought it was something in the paper, but now it's obviously true that there was a conversation about it, and there was, obviously he was not involved in it. But I do now know that it did occur. And why were we not given the information that there was conversation between the Speaker's office, that individual, and that for the potential stipulation of those facts, that there was a recommendation for potential censure? To me, I have to understand all of those issues. Also, there were people who were on the list of witnesses that we wanted to have come forward. Now, we've been told time and time again, well, everything is in the 800 pages. We have two whistleblowers who had the opportunity, obviously, to speak with the legal counsel as well as with our House Business Office Director and put things into a record. They were not under oath. They did not have any members that I'm aware of that were part of that process. Again, we're expelling somebody, and no member was sitting in that. And Mr. Speaker, if you were sitting there, I apologize, but my understanding was that there was not a single member in those conversations and those interviews. So how did we actually now get to a level of expulsion when not a single member has actually heard testimony from these two individuals? Now, I keep hearing, well, it's in the report. But these individuals, if you had subpoenaed them, would have been under oath. And that, to me, is what's the most important piece. And that is one of the pieces that is missing here today, that the two whistleblowers were not under oath, did not have an opportunity to testify. Again, we have talked a lot about the timeliness of information. We talked a lot about the time that we have had to review this. And so my question is, why are we doing this today? This was not even on our agenda today, right? We did not know that we were coming here today to vote on this. Why couldn't we be given the weekend to go through 800 pages and 5 hours of audio? Don't we owe that to this state? Don't we owe it to the 90,000 people before we nullify an election? I think so. And that is why you have heard some of my members that are concerned. Will not be surprised that if at some point down the road, these members are expelled from this institution. Hey, they might be today as well. And if they are gone, that's fine. Politically, for me, having two people of that extreme nature probably benefits me in the issues that I'm fighting for. But that's not why we're here. We're here to follow a process and to understand where we're moving things forward. And I think the last thing that was probably the most disturbing to me was the testimony that we had yesterday. Testimony of the former chief of staff of the speaker who came forward, and then we struck out of the public record his comments. And I just went through, and let me do this for you, because I know many of you have not had the opportunity to read all 800 pages. But, if you did, there's a few pages I want you to take a look at. If you take a look at pages 150 to 160, you take a look at page 660, you take a look at 662 and 673, you will see in that evidence chain that has brought forward this resolution to expel communications between that chief of staff and these two whistleblowers. So it is very clear in the record that has been presented to us that there was information that was available of an unfit environment for individuals to work there. Those two whistleblowers gave us information, but yet found themselves terminated a couple months later. They were whistleblowers, and we did not provide them protection. We have failed those two individuals, and you don't even want to hear their testimony. And that's why you're hearing the concern from many of us, because today our work is not done. I understand people want to get this over with. I want to get this over with. But until I have the two people that started this whole thing under oath, then I don't think we've actually done our due diligence. And then for the historical precedents, allow the Secretary of State, the Attorney General, and the state police to do their work so we can understand the criminal charges. Again, we're going to take the most extreme action, which is to nullify the vote of the people. We do not have all of the information. We do not know all of the facts. And we have time to make sure we do this right, that we have these facts, that we have people under oath, and that we bring them in and subpoena. You put in your resolution, 129, which I supported, that you would subpoena people if possible. That did require us to actually vote today to subpoena them. But you haven't given us that opportunity. So our work is not done here today. It might be done in a week, 2 weeks, maybe 3 months. But we need to make sure that we do all of our due diligence, because I will not make the most extreme action that the Constitution allows without having all of the facts. Thank you, Mr. Speaker, for the opportunity to speak today.
Thank you, Representative Singh.